Okay, can you guys all hear me? Can somebody tell me yes or
I can hear you, Devin.
give me a thumbs up or something?
I can hear.
I can hear you.
Thank you, Carlisa.
I can hear you too.
Okay. Okay, I have no idea why it's doing it this way, but we're doing it anyway. Oh, thank you. Chrissy has the same shirt too. Okay, guys, we're gonna get started. It is 12:03. We're just gonna watch it.
Let's talk
Who
about
do
that.
I file back complaints against?
Let's talk about that.
This is the most intriguing topic you've ever had.
That's really weird.
That's what I said.
Like, swap.
Totally. I was like, I'm in. That's what I said. I'm in.
So I'm glad to hear that because I've talked about this before, and I think it's really interesting that brokerages don't talk about this because here's one issue that if you ever lose your mind and open a brokerage, here's one thing that you will experience every December. You'll be like, start checking on people to pay their dues, because they bill you for the dues if they don't get paid. And you start checking on people for paying their dues, and they're like, I don't even know why we pay these dues. I have no clue. I don't get anything from them. And every other thing you can think that accompanies that. And so one of the value propositions of the realtors is dispute resolution at a substantially reduced cost than you would pay anywhere else. Has anybody ever hired an attorney?
Like for real estate?
Anything? Like, has anybody ever, how much did you pay an hour?
$500.
$500. That was a really good one. That was a good one. Yeah, I mean, 500 to, I've never heard of anything less than $200 an hour. And if it is, you should probably run from that attorney. But that's really the only sort of dispute resolution for the most part that we are familiar with is litigation or attorneys or whatever. But disputes come up all the time, right? Not just with us or with each other, but with buyers and sellers. I've seen disputes, seller to buyer's agent and everything in between. So this is not to tell you every single thing that you should know about that. It's just to kind of raise awareness about the dispute resolution options we have in our business, because right now our market is really super competitive. And that is a perfect storm for disputes to come up. So, and I apologize for how this is, it's not supposed to be, but this way, what are reasons we get pissed in this industry? And specifically, you get mad about a lot of things, not communicating, whatever, but what are some of the reasons or ways that we get pissed or our clients get pissed? They're not getting what they want. Okay.
Under-delivered or promised.
Okay.
Failed septic.
Okay. What else?
House was supposed to be done 3 months ago.
People are crazy. Good one.
And it's not us.
Oh, it's us too, but.
What else? What about lack of disclosure?
Right, inaccurate information.
Inaccurate information? What else? of all the reasons you've like had come up.
Lack of communication. Something wasn't done at the walkthrough.
I don't like fires.
What else?
Sellers are the reason. False expectations.
Condition of property. when you close it, maybe.
Or they took something they want.
It's the way it's left.
Or they
Yeah, they took
left junk.
left
over
junk.
me.
Like, that's, so like leaving junk is, like, a breach of contract.
Yeah.
I've had, the driveway wasn't plowed in the contract, it states the seller shall maintain the property, so they were pissed about that.
What about like bigger issues? Anybody ever have?
I haven't-
Sellers are just looking,
Huh?
that's why sellers are just looking.
Yeah,
I haven't dealt with it personally, but I had a buddy call me, he's using a different realtor, and he was pissed match about square footage.
Yeah,
He's
that's been an
he'll list
issue.
it for one thing, and
That's why you put BTV. That's all that's from.
I'm glad you brought that up because it made me think of a scenario. Okay, so who is the one who is pissed and exactly who are they pissed at? That's really important to know because we're going to talk about types of disputes and types of dispute resolution. But this is really the key. This is where you should start to know which, because we throw a lot of like phrases around like, we'll just take that to mediation, or that's a violation of code, that's an ethical violation, or the term unethical. So I would argue that Devin Thomas's perspective of being unethical is not always a violation of code of ethics.
Right.
So think of that, like your personal ethical moral compass is not necessarily in total alignment with the code of ethics that we pledge to uphold. But who, I mean, so give me a couple things. So a buyer could be upset with the seller, right? A buyer could be upset with their agent. A buyer could be upset with the other agent. What about agent to agent? What are some types of things that we're upset with each other over?
Lack of communication.
Lack of communication,
Stole my client.
stole my client. I'm glad you brought that up because we're going to talk about that. What else?
The other agent's a
Say that again?
The other agent's a dick.
The other agent.
Commission percentage.
Commission percentage?
That's part of the thing.
I'm writing that down because there's a couple places that could be.
Yeah.
Now there's somebody coming. Okay, hold on. I can't let people in unless. Okay. Okay. Okay, so let's talk about handful of places, types of disputes. Okay, so we talked about agent to agent. That could be anything from lack of communication all the way to non-disclosure, stole my client, procuring cause, all of that. Buyer to seller is one type of dispute. Buyer to their own agent, buyer to the listing agent, seller to buyer, seller to their own agent, seller to buyer's agent. Do you think of any others?
Lender,
Seller
seller.
to buyer's lender.
Lenders?
Yeah.
Say that, seller to buyer's lender.
Yeah.
Okay.
Agent to broker.
Agent to broker, yeah. Yeah. That's interesting that we haven't seen more. Because NAR actually has like a perfect roadmap for how that should work. Although sometimes your independent contractor agreements will supersede that on how you deal with disputes within your own brokerage. But these are the main types. So where do you typically go first?
To the email.
To the email. Oh, yeah. That is,
Email.
honestly, that's actually very, very accurate. Like everybody becomes like a keyboard warrior and they're like, no, I'm gonna fix this by typing my email in all caps. Like, and a lot of times, like I see people like trying to resolve conflicts and they don't even actually understand what the contract says. Because here's the deal, we are not here to interpret contracts. We are here to basically facilitate them. So the contract really lays out quite a few ways that we resolve things, but we don't always, either us or our clients don't always want to resolve it that way. The very first person you should go to if you see a dispute coming up should be your broker. Unless you already know the answer to what something should, and this is hopefully to kind of, like I said, raise awareness on what the possibilities are so that you can guide yourself and your client about what the possibilities are. Because I've had people like refer their clients to me and they say, oh, well, we want to go, we want to take this to court or whatever, or we want to file an ethics violation or an ethics complaint against this person. And they don't even understand what that means because their agent never actually explained that either. And that just fuels the fire. When I have to tell them, okay, what you're describing is not actually an ethics violation. Of course, they can always file anything they want, but sometimes it's really, really black and white, or sometimes they need to go a different route. I don't know how many times that we've dealt with ethics violations that people don't understand that if the person is found in violation of the code of ethics, that if they're, I don't want to use the word awarded, sanctioned with a fine, that fine does not go to the person that filed the complaint. Does anybody know where the fine goes? To the board. To the board. To the board. To the board. So here's the places, maybe. Technology is not my friend. Okay, so here are the places. First one should always be broker to broker. And honestly, any of the ones below it should start with broker to broker if at all possible. In fact, there's many, many, many disputes that are resolved this way. The second one is code of ethics. So if somebody says this person violated, or I'd like to make an ethics complaint against this person, what exactly does that mean?
Isn't that like to work for us?
What does it mean? What has to occur?
You have to violate one of the statutes.
You have to, not the statutes, you have to violate one of the articles. And not necessarily, and this is where it's kind of confusing and this always happens, but not necessarily the standard of practice. You have to violate one of the articles. So like I said, somebody could say, well, for example, I've heard it like 300 times in the past 3 months. They accepted another offer without giving us a chance to do highest and best. That's an ethical violation that because they could have netted their seller more money. They did a disservice to their client because they didn't call for highest and best.
Somebody actually filed?
But people talk about that a lot. Yeah.
Aren't there states that require you to do that, from what I've read?
We used to have to do it here, we don't anymore. When they got rid
It's
of
not that you do or you don't.
So,
You are not allowed to without one key piece of information. We'll talk about that in a minute. Ombudsman, does anybody know what this is?
the diffuser.
The diffuser, yeah. Does anybody know what an ombudsman is? So this is one of the things that, when, gosh, I want to say it was like probably in 2014, NAR came up with this set of rules called core standards. And they said, if you want to be called a realtor board, you have to provide this level of service to your members as a local board. And one of those things is ombudsman services. And ombudsman services is basically a phone mediator. So who here knew that we had ombudsman available to you? It's a phone mediator.
They don't really tell you enforcement, they can tell you where to go.
They decide if the complaint is worthy of an ethics violation. right?
Nope, no, we'll actually talk about each of these things, but just ombudsman, phone mediator, just know that for right now. Mediation, does anybody know what this is?
Where you meet up and try to mutually resolve the situation before it goes to.
With a fellow realtor, like somebody that's been, is mediator.
So it can be done a variety of different ways, like, within brokerages, the broker could serve as a mediator. A lot of independent contractor agreements require that the broker does mediation prior to going outside the company. It could be buyer, seller, agent. I mean, it could be a lot of different things, but it is a trained mediator. It's a little bit more of a formal process than just meeting up, but it's essentially that. And the mediator doesn't make any decisions. How many people have ever heard somebody say, we'll just take this to mediation, we know we'll win? I've heard it tons of times. And the reality is nobody wins in mediation because the mediation, the resolution could be no resolution. It could be, no matter what it is, both parties have to agree to it. So there's like if you ever hear anybody say that, that's a little insane. They don't understand what mediation is.
Aren't the realtors not involved in that? It's just the buyer and seller.
It could be, the realtors could be involved. Like I facilitated a mediation that was seller to realtor.
Seller to his realtor.
Yes.
I just had one that wasn't me. They were coming off a bad deal and they had to go through mediation first before they could make ours work. And then it was between the buyer and the seller. And the realtor should take that.
Yeah, and that's a lot of times it's left up to the discretion of the mediator. If they will allow realtors to be there. I do mediations. And so I've had multiple mediations where attorneys have been there. And that's entirely up to the mediator. I actually, believe it or not, was extremely helpful. Very helpful. Because attorneys are like very unemotional about this stuff. Very unemotional. And they're like, okay, this is, and they can also speak in a way that a mediator cannot speak. I mean, anyone that's not an attorney cannot speak. They said, going to court will cost this. Going to court will take this long. The potential outcomes of this at court are this, whereas a mediator can't really say those things. Arbitration. This is kind of the mystery one.
Somebody hears the complaint and then people don't have a say that the arbitrator makes a decision, one person makes a decision.
Yes, yes. So arbitration is kind of a step below litigation. Arbitration panels are typically 3 to 5 people. They 100%, the difference between arbitration and mediation, which are most commonly confused, is the parties make the decision in mediation. In arbitration, the arbitrators make the decision. And it's typically a winner take all. So somebody said, which you never hear people say, we'll take this to arbitration, we know we'll win. That would be a legit statement if it were true or whatever, but arbitration, there is a winner and a loser, and it is final.
I don't think it was fun. The whole idea is that you can actually take it to court.
That's mediation.
Mediation.
So who's the arbitrator? Is it a judge?
It's a panel. We do have trained arbitrators through the Realtor Board, none in the valley. And so my understanding is that the Valley Board of Realtors has not seen an arbitration in 20 years. In some, they say that sometimes in the context that they're very proud of it. I'm not actually sure that's actually a good thing. Because has there been no disputes in 20 years? Is every single issue or grievance or pissed off person been resolved just broker to broker in the past 20 years?
Probably mediation.
No, there is a loser somewhere, and there's, and this is just Devin's soapbox for 2 seconds. I think the loser a lot of times is our industry. Because if you don't get resolution to problems, they'll go down the litigation road. They'll realize it's too expensive. Does everybody know Dana Lynn Darwinpool?
Mhm.
So she told me one time, this is just a good rule of thumb for you. I mean, it's not, I would never give somebody legal advice, but she said, just a good rule of thumb. Nothing's worth litigating unless you're stand to get 25 grand at least. So when people are like, I'll sue them over $1,000 or something like that. I mean, sure, you could go down the small claims, avenue, but in the amount of time that civil litigation takes is insane.
Well, that's not cheap either.
No.
I think it is, but it's gonna cost you, what, $300 or $400 just to start it.
So the one mediation that I did this year that did not resolve was over 50 grand. And that's where attorneys were. And the attorney just looked at his own client and said, look, this is gonna take 2 years and 20 grand minimum to litigate over $50,000. So, and there's no guarantee at the end that they'll pull that civil rule, whatever, where the other side has to give costs and expenses. So are you feeling lucky? So just something to be aware of, when people start throwing, another thing is like people start throwing around like the sue word a lot in real estate, and it's scary. It's really scary. And you have to know that 9 times out of 10, they just want somebody to vent to. Then we have kind of our own little governing boards, which are ways that we can pursue justice for wrongdoings. One is the real estate commission. What kind of complaints would be appropriate for the real estate commission? Okay. Representation, that's a huge one.
Failure to disclose.
Failure to disclose on the realtor's part. Yep. So similar to code of ethics, in order to pursue a valid complaint with the real estate commission, they have to violate one of the real estate commission's statutes and regulations. So if you want to pull those up, that's a good way to look through them. They do not get involved in contractual disputes. They do not get involved in anything to do with landlord-tenant. They do not get into brokerage disputes, and with a few little exceptions, like brokerages not paying their agents, like inter brokerage disputes. Basically what they're looking for, the big one, read through the AREF. That's pretty much what they're dealing with is trust monies issues, lack of disclosure on the licensee's part, representation issues, disclosures of conflict of interest, confidential information, that type of stuff.
How often have you seen, I don't know if I said the word right, the surety fund being tapped?
So in order to tap into the surety fund, you have to get a judgment, which requires litigation or arbitration. So sometimes people will be like, we'll just file a real estate commission complaint and tap into the surety fund. You will have to pursue that agent legally.
Have you ever seen it awarded to anybody? I've never heard of it.
Nope. That's why they keep lowering our dues, because the surety fund has too much money. Like one time, I don't remember when it was, Carolyn, you'll probably remember, when they tried to make our license renewal fee like $950.
Oh, yeah. We all had a cow.
So, yeah, $950.
That was like 4 years ago. It wasn't that
No,
long.
no.
5 years ago.
It was way over 10 years.
Was it really?
Yeah.
Oh my God, see, I'm having so much fun.
Yes, way over 10 years ago.
Wow.
And just 2 seconds for RPAC. RPAC actually stepped in and fought that. And the problem, this is like not relevant to this class, but the part of the problem is that we all fall under the Division of Occupational Licensing. And all of the investigations, like how they come up with how much it costs us to get licensed is partly based on how many professionally licensed people we have in the state of Alaska. All professional licenses, you know, I don't know, all contractors, who all gets professional license, I don't know. Hairdressers, all of that stuff, and so the budget is set based off the division as opposed to just real estate alone. That's a whole nother soapbox. MLS board.
Good for nothing money, so.
I will tell you, MLS board is no joke. It's like the one self-policing entity that I feel like will actually do something if there's a problem. Even if there's not a problem. MLS board is no joke. Like I've seen legit MLS fines, big ones. And then we've got also good old litigation. So for our 3 kind of policing boards, we have our code of ethics, real estate commission, and MLS board.
Who's on the MLS board? Are there realtors on, or is it just MLS?
It is realtors. Well, it's not necessarily just realtors. Because our MLS is broker owned, not realtor owned. So that's why we have, so you don't necessarily have to be a realtor to be a member of the MLS, which is very different than a lot of other places. Fairbanks is one. You have to be a realtor to be a member of the Greater Fairbanks MLS. We sold our MLS in 2006.
The worst thing ever.
It is the worst thing ever.
Like.
Yeah.
I will never
I've been in
forget.
business very little, and I can just see that was the dumbest thing to ever do.
I will never forget the meeting where they voted to do it. I will never forget it. I was just young. I didn't know anything, but I was there. People were like, people that are like old timer, big shot agents at the time were screaming at each other. And basically Valley Board of Realtors sold our MLS, the Valley Board of Realtors MLS, to Alaska MLS.
Yep.
In exchange for a lot of money. So Valley Board of Realtors building, they own that outright. That's what they bought with the money, which is cool. We're the only board in the state that owns their building. But what did we exchange?
So Mark Lee and I were the only holdouts for that. We did not want to sell it to Anchorage.
Yeah.
You remember that?
We didn't sell to Anchorage. We sold to Alaska MLS. Anchorage
Right.
sold that out too.
Right.
Yes.
We did that exact same situation in Washington State. We sold it. Half the people were on this side of the fence, half the people were on that side of the fence. The sad part is, 2 months after they sold it, they said, oh, we were wrong. Kentucky kidnapped
Yeah. A lot of people feel that way now.
destroyed it.
Yeah, we've been paying for it in many different ways ever since. I mean, like all of the for sale by owner companies, the $1 commissions, all of that, none of that occurred before because we're a private trade organization. We can make our own rules.
Well, prior to that, could Anchorage sell here or access your MLS? Is that
So
something
no,
that-
it was
No,
so.
it was a separate board. But it was a
So,
small
well,
fee to be a member. You were a member of one, but then it was a small fee to be a member of the other one. It wasn't that big of a deal.
It
And
was.
then you had 2 boards.
But the part of the problem, what caused the problem, I think, or what kind of prompted it, is we subscribed to 2 different MLS programs. So we were using we were using Paragon and they were using
Yes.
Wildfire or something
Yes.
like that. And so you had to know 2 different MLS systems.
Which was
And you
fine.
had to double
I
input.
did.
And like, I mean, because we didn't have all these fancy tools to auto syndicate all this stuff. And so people were like, well, this is ridiculous. Some of the people in Anchorage, and back then, it was not as common to see an agent out here go sell in Anchorage and vice versa. So, okay, so broker to broker disputes, that is kind of self-explanatory. If you're having an issue, I mean, that's typically where it should start. Just trying to work it out with the other broker. Can it be worked out? How can it be worked out? I mean, most of the time these things are over like transactions, earnest money, lack of communication. That's probably like the number one thing is like your person won't call me back. Your person won't answer my emails. Your person won't whatever. And then working it out that way. We won't get too much into that because I think it's kind of self-explanatory. Code of ethics. So as realtors, we take pledge to abide by these code of ethics. They're updated every single year. Does anybody know the process if somebody, a consumer, so it has to be a consumer, or I guess let's talk about the requirements to file a code of ethics violation.
Money in a form?
No money. No money. Form has to be on our website, so it is on our website. If you have, usually they bury them so people can't find them, so they don't have to deal with a lot of frivolous stuff. But in the event that one of your clients feels that they've been wronged, either by you, probably they're not going to be speaking to you about that, or maybe the other realtor, which we've had quite a few of, like especially with like non-disclosure. One of the code of ethics says we will not exaggerate. I've had that multiple times in code of ethics issues. So what the process is, they fill out the form and they have to identify all the different places within the code of ethics that you violated, specifically the articles. So exaggeration is one of them. We just had one listed the house as a 4-bedroom. House doesn't meet what the buyer perceived as the requirements for a 4-bedroom, meaning it had a 3-bedroom septic. It said nothing about that. And did not have an egress window in that 4th room. So they filed a code of ethics violation for misrepresentation or exaggeration of their listing. And they did not file it against their own agent. They filed it against the listing agent.
So then what happened? What was the result?
So the results are private.
Well, I'm just curious because you can have a 4-bedroom septic with a bedroom without egress. Tough crap. The
But if
buyer
you
can
don't
take
disclose that,
Huh?
then that's a problem.
Okay.
Didn't the buyer to verify everything just catch it all?
Yeah, I mean,
Huh?
oh,
Didn't the buyer to verify everything catch it all?
Apparently not. I mean, I honestly sat on the grievance
I'm
committee.
curious
So this is what you should know about the process. And I don't think it's important for you to know every single step of this, but it is important for you to be able to tell your client that this is what's going to happen. So you're going to fill this out. You're going to say, my agent or the other agent, let's just use this example. The other agent exaggerated what this was, maybe the utilities. Let's give that example. What the annual utility costs were. They exaggerated that, so I'm going to file this complaint. The next thing that's going to happen is that complaint is going to go in front of the grievance committee. Does anybody know like what is a parallel system we have with the grievance committee? It's very similar to a grand jury. If they're not saying, yes, they did it, no, they didn't, they're not imposing sanctions or fines or anything like that. They're just saying, if everything the complainant says is true, this is a violation of the code of ethics, which is the same thing. Has anybody ever been on grand jury?
Mm-hmm. That's gonna go to court.
It's way cooler than grievance. It's way more interesting. So yeah, and then they say they pass it on to the professional standards committee. The professional standards committee then forms a hearing. And the hearing is, I guess, similar to an informal court sort of thing. And they typically, I've seen 3 or 5 realtors that are certified in professional standards that will hear And then both sides will get, the person that the complainant, the respondent will get the opportunity to bring their own evidence, their own witnesses, their own response. In grievance, you do not. It's just the complainant's information and you're assuming it's true. Does that make sense? So if somebody's like, hey, I want to file an ethics complaint, because it's funny because consumers all the time, like, will call like the board of realtors and say, the seller didn't disclose something, so I want to file an ethics complaint. Okay, well, that's all wrong for so many reasons. You can only file an ethics complaint against a realtor. So if the person that is perceived to be in violation is not a realtor and just possesses a real estate license, that you cannot go through this process. So, there's also some code of ethics stuff that could be dealt with realtor to realtor. So like one of them is stealing people's clients, and how that looks. And I really like challenge you guys to go read through that sometime, what it actually means, because just your perception that they stole your client is not necessarily in line with what constitutes an ethical violation of stealing your clients. We were just talking about the other, Janice, I was talking about it. I was teaching the code of ethics like a couple years ago in Anchorage. And does anybody know Jeff Schroeder? It's like an old time agent. He used to represent Spinell. I think he's like has his own little no-name brokerage out of his house now in case he feels like doing a deal. And he stands up and there's like 100 people in this room. And he's like, you young people need to understand something. The one who gets to the contract first wins. And I was like, and we're in a code of ethics class. And in some ways that can be true. Especially right now where this might be an issue. So this is a code of ethics, standard practice 1-15 that I think is really, really interesting, and one that a lot of people don't know about. So realtors, in response to inquiries from buyers or cooperating brokers, shall, with the seller's approval, disclose the existence of offers on the property. Where disclosure is authorized, realtors shall also disclose, if asked, whether offers were obtained by the listing licensee, another licensee in the listing firm, or by a cooperating broker. So what does that mean?
That means if you have a mad realtor because they didn't get the deal and they ask you, is it yours? Are you double sided? Then you better answer truthfully.
Only if you have the seller's permission though.
Yeah, you just say-
Yeah, only, yeah.
That's
Only if
the
you have-
natural.
I mean, the catch to this that people don't understand is it says twice with the seller's approval or where disclosure is authorized. So how are you obtaining this authorization? In writing. I've seen people do it because I know somebody that has been called to the carpet on this. And I've seen people do it in the listing agreement that set lines out like what your personal business practice will be for multiple offers.
That's smart right now.
Yeah, like during multiple offers, and maybe this is a conversation you should be having at your listing appointment. When we get multiple offers on this property, and if in our market right now, it's very likely, how do you want that handled? I want the most money. Okay, well then this is one option. We could send out a multiple offer disclosure in the event. This is the pros of that. This is the cons of that. Because has anybody ever lost the best offer in multiple offers because they just said, we don't want to play?
Yeah,
I have.
yeah, absolutely.
So they need to be made aware of those risks and then say, no, I don't want to do that. Then don't tell anybody. We'll just let the offers come in and they can accept an offer if they want. But you should be having this conversation with your sellers. You don't get to make this decision on their behalf without having the conversation. And I feel like anytime anything says with seller's approval, like the most prudent practice of that way is in writing.
Right.
I've seen people do it in the listing.
The other time you get in trouble with this is if somebody has an escalation clause, then they want to see proof that their escalation clause either did or did not apply. And that's tough because sometimes the seller doesn't want you to disclose that.
So I've had other
And I've
agents
had that happen.
deal with that on the opposite when I was representing the buyers. And they wrote back, no escalation clause will be exercised and countered at the very top price I wrote on the escalation clause. So let's say 300,000, the list price is 300,000. I write you an escalation clause and say, I'll beat any offer by $500 up to 310. You have to provide me proof of any competing offer if it goes over 300. You write me back and say, you write me back in a counter and say, no escalation clause will apply. First price to be 310. I mean, in fact, I think it could be argued that escalation clauses in some ways could violate buyer's negotiating position. Jim loves them. You love escalation clauses. I mean, you just need to know that the sellers really make the rules. So the seller does not have to show you that other offer. But at the same time, that was a condition of the buyer's contract. So if you don't, the buyer could back out.
Right.
I actually have had that happen to me more than once recently, where they said, we will not be showing you the other offers. Not unethical. That's what the seller told them to do. And we told them the max price we would pay. And that's what they got. So, but in seller's approval and disclosure is authorized are key terms in this. Ombudsman, like I said, this is phone mediation. So the good thing, there's a couple things about phone mediation that you need to understand. One is if there is a phone mediation that involves you and the complaint is either you are making a complaint against somebody else or somebody is making a complaint about you, and an ombudsman is approached to get involved, that requires that I give permission. Since when? Since now. And let me tell you
I'm
why.
just asking,
Let me
because I
tell you
didn't know
why.
that.
Because if they tell me the ombudsman is Billy Bob is gonna be the ombudsman, and like ultimately you are under my supervision and I'm liable for your actions, I don't necessarily trust what Billy Bob says.
You want to.
So I get to say, no, we will not participate in that.
Actually,
Billy
we
Bob
did
is the
that.
ombudsman.
Do you remember the tenant that was mad because I kept her $500 security deposit, but she had a ferret that peed all over the bedroom? Beth Freed was the ombudsman and she wanted to make a big deal out of it. And Devin and I are like, we're not even gonna entertain this.
Yeah.
Remember that?
Yeah, I do. Your fun stuff you let me do. So that's one requirement. They're typically a mediator, somebody on professional standards. It's confidential, it's informal. The really nice thing about ombudsman is it handles a lot of minor complaints. It's very underutilized because, does anybody know how much mediation costs?
Is it 250?
It's 300 per side. So if you're arguing over $1,000, like an argument we've had lately, most recently, is items were on a bill of sale and the seller took them, and the seller was like, "Oh shit!" Like, yeah, sorry closed. Huh?
I said, what happened? Did they have to?
We just have very disgruntled people.
Yeah,
That's the thing. That's why I don't think it's necessarily a good thing that arbitration hasn't been exercised in 20 years. Because you just have some really disgruntled people about the real estate process in general. And then when it comes time for us to like technology to take over, these type of people are the people supporting that because they're like, yeah, they didn't help me. You know, so I mean, we have to really look at it like holistically about like what does like utilizing this stuff mean for our industry. It doesn't determine if violations are occurred, so that is supposed to be made very clear. Like an ombudsman, a good trained ombudsman shouldn't say, "Ooh, that's against state statute." That doesn't happen in mediation either. Like one of the scripts as a mediator, when you're setting up the room, is like, I'm not here to determine if something was illegal, a violation of code of ethics, how this would turn out in court. Like, I'm not here to determine any of that. It doesn't actually even matter. One of the resolutions that we reached in a mediation was a week-long stay at somebody's vacation rental. Because the person that technically, yeah, they didn't have any money.
Oh, gotcha.
They didn't have any money, but the other side made a very good case that they owed them money. They didn't have any money and that's what they had to offer and they took it. And I mean, the resolution can literally be anything. And it doesn't have to be right. Like there's ones that I'm like, oh, I feel like if you took this before a court, it would not turn out this way, but you don't get to say, like, mediators don't get to say, no, that's not right, that's not fair. It's whatever they agree to. Same thing with ombudsman. They don't determine if there's how something would, they're not supposed to speculate about how things would turn out in court, an ethics hearing, any of that. They are just basically informational. A lot of times they call it like informational and educational, because sometimes somebody wants to hear somebody totally detached from the situation give like an interpretation of like, oh, well, the contract actually reads that, until the inspection period is up, a buyer can back out without being in default for pretty much any reason, when that whole paragraph, I think it's G, that says includes but not limited to, and it gives like a million things. Square footage is one. Like I said, sometimes people just want to be heard. We do have this available through Valley Board of Realtors. And we have a couple really, really good ombudsmen. Actually, Vicky Cass is one of the best ones I know. I mean, she's excellent.
Wasn't Marty for a while too?
Yeah, Marty was good.
I don't think Marty did ombudsman, because Marty was very peculiar about, he did a lot of mediations. He did mediation forever. And he wouldn't, probably why he doesn't want to do mediations anymore is because he would not do them unless all parties were there in person. Well, sometimes people leave and, and now they're doing most mediations by Zoom, which is really tricky. Okay, so let's talk about mediation. It is collaborative, promotes a win-win, although I'm not sure everybody always feels like it's a win-win at the end, but they at least know like over. Because even though it is non-legally binding, it's non-legally binding in the fact that you do not have to reach a resolution. That's what it means by not legally binding. At the end of the mediation, if they come to a resolution like, I will give you a week's stay at my vacation rental, all parties sign it right there at mediation. It's cheaper and faster than litigation. I think the cool part about it is the parties decide what the resolution is. And that resolution can be literally anything. I mean, whatever they decide it was. I've seen them at the end where they're like, I just want you to apologize. Like, you screwed up and I want you to apologize. I want you to admit you wronged me and we'll call this good. It may maintain and improve relationships. I've never seen one actually that at the end of it where they were like hated each other. Like it's very interesting. It's hard kind of now from Zoom because people don't. There's like a lot of power and like. I think this is the problem with disputes is like goes back to what you said in the beginning. There's a problem and we become keyboard warriors and we feel like we can say anything and you would never dream of saying some of these things to somebody's face.
Right.
And some people are really eloquent writers or really love like the law or contracts or whatever, and they think they're gonna like bully their way into getting whatever it is that they want. And there's just a lot of power in people being face to face. But like I said, there's not any certain resolution. It can literally be anything as long as it's determined and agreed on by both parties. So what does our purchase and sale agreement say? It says if a dispute arises relating to this purchase agreement, between or among buyer or seller, and it is not resolved prior to or after recording, the parties shall first proceed in good faith to submit this matter to mediation. So if a dispute comes up, sorry, they're walking my lot right now. If a dispute comes up, the first thing you should say is, what we need to do is we need to have you fill out a mediation packet. Right there, you will know how serious they are about the issue. And that, I mean, you should be very unemotional, and even like the seller said they were gonna leave the deep freezer and it's gone, and I'm pissed and I want justice for my deep freezer. Okay, so the first step would be what? Try to figure it out with the other agent. Does it work?
Sometimes it's a mistake. They're military. This happened to me and the movers.
Just
took
took
it.
it?
They didn't mean to, but the freezer's in twice. So now what do you want to do?
Right, so, and they don't have money to buy a new one or whatever,
Usually.
and, it does, that does suck. Costs to be shared by mutual agreement between or among the parties, so $300 aside is, I mean, right there could stop it when we're talking about the deep freezer. They're like, okay, well, I can go buy a new deep freezer at Costco for $400. So let's just save everybody the headache, and that sucks. And you
And I
can
was getting them
decide.
a housewarming gift anyway, so here's $200 and they.
Sure, that is a resolution. Unless otherwise agreed in mediation, the parties retain their rights to proceed to arbitration or litigation. So that's the key, unless otherwise agreed in mediation. So you go to mediation, they're like, nope, I'm not buying your deep freezer, I'm mad, we're not resolving this, that they would then retain their rights to go to arbitration or litigation. Probably arbitration first, because it is cheaper, but not a whole bunch cheaper. If the parties have not agreed to mediation within 30 days from the date of the original dispute, it will be assumed that they do not wish to mediate their dispute, and the broker will act accordingly. So dispute between buyer and seller, first step should be mediation. And I would just be as simple as direct them to the link on the Valley Board of Realtors page. Here's where you go to fill out the mediation packet. Here's their number if you have any questions. Any questions about mediation? Has anybody ever had somebody want to go to mediation? And
Yeah,
how-
my first deal ever, I think, as a realtor. Yeah, new construction, dry well. Start 4 months behind. Just build it back it out, it never went nowhere.
It never went anywhere. So some of that too, so back to code of ethics, if somebody files it against you, you are required to go to, I mean, you said you would participate in mediation if somebody files it against you. Our clients did not sign the, code of ethics. So we can't force anybody to do anything. But this contract does say that they will. And if your client wants to pursue it further, chances are they're going to have you first, try mediation, especially if it's over something really minor. Okay, arbitration. It's very confrontational. They define winners, losers. It's slower, costs more. The only thing you take to arbitration is disputes over money. That is what it's over. I mean, that's a really good way. Some mediation, you can mediate ethics issues, you can mediate money, you can mediate a lot of different issues, but arbitration is specifically for financial damage. It is a winner take all most of the time, although I've heard differing opinions about arbitration boards, like splitting money and things like that. But typically it is a winner take all. It's a you are right, you are wrong. The arbitrator or arbitrators decide the outcome. A lot of times this can reinforce the division between the property, the parties. It is not typically a process that unites individuals. It is very much like you win, it's very similar to litigation. It's just less of a formal process, and it gives a definitive resolution. So this is the most common topic that is seen arbitrated among the real estate industry, although not necessarily in our area. So I just want to talk about this for a minute because it comes up every once in a while as so-and-so stole my client. So has anybody ever felt like somebody stole your client? So there's a couple questions you should ask yourself first before you decide you want to put any time, energy, or money into a procuring cause case. I do know some procuring cause cases that have been taken to court and won. First of all, what type of relationship did you have with the buyer?
A buyer agreement.
A buyer agreement. So does a buyer agreement constitute procuring cause?
If you've shown them that particular house, and you can
Possibly.
when they turn around and buy it.
Sure.
I think the buyer agreement is only the responsibility of the buyer. Person signing the agreement.
It is not to all the
Yes,
other
it's not to
real
me,
estate
yeah.
professionals. That's
So if I
correct.
stole your client, and you have a buyer agreement, or your client bought a house from me, say I didn't know it in the buyer agreement, I said, well, that's your problem.
Yeah, you have to take that up with them. So there's they actually provide you with that arbitration worksheet, and it's very interesting, all of the questions. It's like 20-something questions that they go through to determine whether something is potentially procuring cause or not. Some of them are kind of obvious. Was there an offer of compensation made through the MLS? A lot of times, yes. Is the claimant to a party to whom the listing broker's offer of compensation was extended? I mean, like all these different questions that they go through if you're going to arbitrate procuring cause. How was the first introduction to the property made? Like, who's the first person that brought him there? Did the buyer find it on their own, or did somebody you sent to them? Who first introduced the purchaser to that property? Have they shown them any other properties? Was the introduction merely a mention of the property? Did they attend an open house? I mean, there's like all these questions. So just because you come to me and say, hey, I have a buyer brokerage agreement, haven't talked to these people in 6 months, but they just bought a house with Billy Bob. That's probably not a great case for procuring cause. And yeah, Billy Bob is not in the contractual agreement with you. The buyer is. And so a lot of times people are like, no, I want to go after Billy Bob. They don't want to go after their client.
Well, a lot of
Their
times the client
client.
doesn't tell Billy Bob, they have a contract with him.
Oh, they absolutely don't, all the time. And they could also say, there's this isn't a code of ethics class, but there's some things like some provisions in there where like if the buyer says, I know you have a contract with Amy, I have a contract with Amy, but I want you to write this offer. That you're not doing anything wrong by writing it.
Yeah, and I always go a step further, and so what is it about Amy that you don't want her to write?
I mean, I would be careful of those type of people.
Right.
Yeah.
And then it's up to Amy if Amy wants to go after me, but Amy cannot go after you.
Right.
If you knew the information, yes.
Ironically, Renee and I had a deal together, that's how we met. And I was listing, she was buyers, listing canceled. And the seller went to her buyer and said, let's work without the realtors. We had the seller get rights, hook, line, and sinker. But in the real world, title company held the money, attorneys were hired, and without the seller's agreement to give us the money, We didn't have a competition, though we had our dead rights
Wait.
contractually, one second. Because in the real world, just what you said earlier, the seller wanted part of that money. And
Right.
so that was the only thing what made the seller settle. So we got half the commission, even though we were dead to rights to get it all. It would have been years and thousands. It would have never worked. So it's really funny listening to what we think is the rules and the laws against the real world. Yeah, none of this stuff we're talking about is true to the real world.
Did you have the days in that little box over listing where it says, I was just curious.
Up to
if you-
180.
Okay.
Yeah,
I
we
was
had
just curious.
dead to rights.
So what about the whole, like, we show the property, we get a percent. If I showed the property to somebody before, what was the offer? I saw it.
So you should really turn that into, because, so, you know what, so points for who knows what that violation is. That's an MLS violation.
Yeah, I used to,
Because I would think I didn't. see that.
because
I
the
mean,
brokerage got in big trouble. for
That is
doing
an
it.
MLS violation.
I don't know.
Yeah, and like I said, MLS is like the one board that is like no joke. Procuring costs, if you didn't know what it was, it is where you are claiming that you were the reason they bought that house and that you are entitled to that commission. And it is a harder hill to climb than you might think it is. It is not as simple as, here, I have a buyer brokerage agreement, or even yet, my favorite is like, I have a neighbor, I signed from them like 3 months ago. I'm like, good for you.
They
Like,
registered on the website.
yeah, that's the law.
Is there really nothing that protects you then? Like if you've been showing someone tons of properties and they last minute go with somebody else and end up buying, there's nothing that really protects you?
Not really, unless you want to take that buyer brokerage agreement to court against the buyer.
Hmm.
And most people, they're super quick to want to like get the other realtor in trouble, but they don't want to go, they're like, oh, I'm not going against them. That's my friend, or I know them, or whatever. They want to get their competition in trouble, when in fact their competition didn't necessarily do anything wrong in the rules of that we are governed by. Okay, real estate commission complaints, I know we're over time, so real estate commission complaints, just a couple things. Again, they have to violate a statute or regulation. If somebody says, I'm filing a complaint against you with the real estate commission, you would immediately contact me about that. It happens. I would say, I mean, I've probably seen 25 real estate commission complaints for people that I've supervised. Now, here's the trick. Our independent contractor agreement says you will tell me. The real estate commission will not. They do not have to.
Do they get involved in all of this? contracts?
So if I go to the real estate commission and say, I heard that Renee had a complaint filed against them, and in her contract, it says she has to tell me about it, they will say, screw you, Devin. Get out of my face.
It reminds me, Devin, they filed a complaint to the real estate commission.
Oh, you did?
I did last week.
Oh. I don't care if you file a complaint against somebody else. If a complaint is filed against you, and sometimes the first you'll know about it is a letter in the mail. And
From
they'll
the
send it to
real
your
estate
home,
commission.
they'll send it to your home address or whatever. And that is the first you will know about it. A lot of times they're frivolous, like a lot of times they're ridiculous. People are mad about, I mean, really ridiculous things. But you still have to go through the process and it sucks.
I'll
So,
send you that email.
okay.
It was an old one. It was like 2 years ago, and then she came up again and she was bugging some other people. The real estate commission did nothing with it, so I refiled.
Oh.
Because people kept calling me, hey, what's up with this person? I'm like, she's still around. But she-
Trying to sell houses without a license.
She was selling one of my houses without a license. Let it go. It's a lawsuit.
So if you have a situation where your client is mad at the other agent and says, who do I contact? This is what happened. My goal for this class is really for you to be able to direct them to the right place. So if you believe that they violated, a statute or regulation, let me give you an example. I'm selling a house, for a client, Lori brings the buyer, and you later discover that the person that I'm representing, is actually my business partner. And I did not disclose that. That would be grounds for a real estate commission complaint, because that's lack of disclosure for a disclosure of conflict of interest.
That'd be like May and Garrett saying that they're not married.
Sure.
Why is selling your business partner a house?
Disclosure of conflict of interest, read the form. If you have financial interest, or are in some sort of financial relationship with the person that, financial relationship beyond receiving real estate commissions from it. Real estate commissions don't apply to this, but like, let's say you and I own a weed business together. Let's say we own a weed business together, and I'm gonna represent you on a purchase of something, but I'm not gonna tell them that we're business partners.
Don't you think we should use fictitious?
Yeah, we
So,
we
I
don't.
could see that being a problem if, like, if I were purchasing like a warehouse to do a grow. But if I'm
You
buying
have-
a house, what the hell?
I don't make the rules.
So if I, so you
I'm
have a
just telling you
personal
what the
trainer,
rules
you
are.
pay your personal trainer, do you have to disclose you have a business relationship?
That's not
or you-
business, it's like a business partnership.
Okay.
So another one would be, let's say you're selling a property, you have a house listed, and, it's a house that is being flipped, and your husband did all the work.
That I can see,
You have to litigate.
right.
I mean, even in the sibling thing is kind of a weird thing to me, but that's what the form says. And I'm just trying to save you a lot of
I
headache,
get it.
because I'm telling you, the process is lengthy, it is not fast. Because what happens, again, the process of it is the person fills it out, they send you a letter, you have 14 days to respond with your documentation, and then you don't hear anything for like 90 days. And meanwhile, you're like, because this is the one entity that has the ability to take your license. So I've had people say, like one time I remember I had somebody say to somebody here actually, that they were gonna take their license, and it was somebody at a board level. And I was like, the boards do not have the ability to take licenses. They do not govern license law. This is the only entity that has the ability to do that. They can, and I think it was Shyla that said the only reason they take licenses is for fraudulent misrepresentation. Negligent misrepresentation, like I'm an idiot and I should have known better, is different than I knew exactly what I was doing and I was trying to deceive. So that is like the main reason you will lose your license. Otherwise, they're going to impose huge fines, and then you also get a cute little note on the state website next to your license that says on probation until whatever such and such date. So if ever anybody under the sun gets on the website and looks your name up under professional licensing, they get to read that note. So not a fun process you want to go through. Alaska MLS board. I just want to direct you to these. Does everybody know how to get to this?
Yes.
So you go into alaskarealestate.com, you log under your login. Alaska rules and regulations. It's really interesting what's in there. This is the one that I see most commonly violated, coming soon. Shall be defined as those listings which meet the following criteria. A coming soon listing shall have a valid listing contract, but the listing is not to be classified on market or until the specified showing date. Seller and broker will permit no showings before the start of the showing date to allow seller to prepare the property for future showings. How many times have you been called on a coming soon to say, can I just see it really? Can we just see it?
No.
Okay, you are violating MLS guidelines, and I'm telling you, whether I think that's okay or not, they are no joke. They will find the crap out of you. They
Yes,
like it. They
they
like
will.
it. AKMLS is a for-profit company. No offers or purchase will be, no offers of purchase will be presented or accepted before the start showing date. The listing is deemed to be unavailable until such time as it becomes active. I see this happen all the time.
Oh, yeah.
All the time. What is a resolution to this?
Hey, fine.
Don't freaking put it as coming soon. Don't put it as non-MLS or like, there's a lot of resolutions to this, but do not put it as coming soon to let all of us know about it. And then, I mean, that is the purpose of coming soon. And people are like, well, you have to present all offers. It says right in your MLS thing, you can't, you cannot. So I'm just telling you, you don't want to mess with the MLS board. That is the one entity that like makes me shake even more than a real estate commission, because they will find you. And if you think like getting a little probation violation on your license is bad, try losing your MLS access.
Yeah.
I mean, they might as well take your license. It's better than taking your license, actually. Like, I mean, without MLS access, you're done.
So are they allowed to put a sign out front, yard arm and all that saying coming soon, but it's not in MLS, it's coming soon?
As long as it's within 30 days or 3 days. 3 days. But like, you should read through this. I mean, it's actually kind of interesting. It's not as boring as the statutes. You'd be surprised because a lot of these things you'll be like, ooh, I see that all the time.
And you can collect offers, you just can't present them
Correct.
until it's active.
Correct. Correct. And the seller can accept any offer they want to accept. But you are not to present offers to your seller until that listing is inactive if you are incoming soon. Seller has consented to a marketing plan from the broker intended to generate interest for the property without the property being available for showing until the start showing date. And I'm not saying whether I agree with it or not. That's not what I'm saying. I'm just saying, telling you, this is like, I copied and pasted this directly out of this little tab right there. Okay. Last item, good old litigation. So again, take it at whatever value you want. This has to be over big money. It really does. To make it worth it, just the time is crazy. Like, and it's probably even slower. Like, she told me that before COVID. So, I mean, civil litigation is not a high priority on the court's calendar. It's just not. So is the complaint against you? This is the biggest thing I want to drive home. Is the complaint against you? Sellers like, or buyers like, hey, they didn't tell me that somebody was murdered in this house. Did you know about it? No, I didn't. Should you have known about it? I don't know how I would. I just got my license 2 weeks ago or whatever. I just moved here or whatever. Okay, well then you need to remove yourself from that situation. And you just say, these are your options. Mediation, litigation. Here's a list of attorneys if you want to do that. I mean, you need to remove yourself from the situation because we insert ourselves into, a lot of times we take on people's problems and then the problem all of a sudden involves us when it didn't need to. Non-disclosure by a seller is an issue between the buyer and seller. It is not our obligation to independently investigate like what they write in their property disclosure. Although I will tell you, take that with a little bit of thought, because if you should have known something, you could be held responsible. But if you have no way of knowing, I don't know.
What's something we should have known? I'm just curious. So what if you're buying a foreclosure and
Yeah,
there's
what's something
nothing
we
like
should
that,
have
nobody
known?
knows about anything, but the neighbor comes after you're pending in your contract and says, oh my God, the guy hung himself in the basement. Do you have to tell the
Yes.
buyer that?
Absolutely.
Yes.
Absolutely.
Does that name, even if it's still the new buyer, you're dead.
Because there's one that's right now listed that my client slash friend had committed suicide in. And I
That's
like,
your friend.
yeah,
I understand.
and let them know, let the listing agent know, yeah, and he's like, great, thanks. Like, I
And
didn't know
now
that.
they're obligated. And that's not a realtor thing, that is a license law thing. But if you are not involved in the situation, remove yourself from the situation, be the source of the source. Here are your options, here's where you should go, and let me know if you need any information. Provide you with the seller's disclosure where they clearly checked, nobody has been murdered in this house. I can provide you with the seller's disclosure where they said that the utilities were $100 a month. I love when they put 1,200, that's my favorite thing. And, they're actually 500 or whatever, this is what, yeah. So let me just give you an example on grievance, where we're talking about the septic issue. If you went back to the history of that property, it's very clear, the lease is posted right on there. So like, who is like, I think both agents have some liability there because that a 1,000-gallon tank is not a 4-bedroom septic. And why is the entire time does, and they're like, well, I give this to the buyer. Well, they didn't know, but you should know. So you should know. I think
that makes sense.
As opposed to like, if there was no way you could have known, remove yourself from the situation. If the complaint's against you, you call me immediately. Our E&O policy requires that. And there's a whole procedure we have to go through. That's if they say, I'm gonna sue you or.
But
get
that's
some sort of-
interesting, because if you were licensed 2 weeks ago, you would not know that a 1,000-gallon septic was not a 4-bedroom.
Guess who's liable for that?
You,
The broker.
that's what I just said.
Lack of supervision. And I have not seen
That's
that.
bad.
So the real estate commission changes a lot. So it used to be the old real estate commission, if a complaint was filed against this will scare any of you guys off, ever be the broker. So the old real estate commission, this was probably like 7-8 years ago, when a complaint was filed, they would file 2 complaints. They would file it against the licensee and they would file it against the broker for lack of supervision. And then they would determine if the broker, like, so this class right here, we keep a log of all of our education because I have to prove either I didn't know what you were doing, and I educated you enough about what you were doing. So that, those would be like your defenses as a broker for supervision. They do not do that any longer. And I think it's like a choice of the real estate commission. So litigation, if you get a letter from attorney or whatever, you need to contact me right away because like I said, we have procedures we have to go through for, if it's not against you, provide the information and stay out of the way. It's not your fight to get in. What's the worst thing you can do when people are pissed?
Ignore it.
Well, I feel to the fire, but honestly, that I don't even see people do that as much as I see, they just ignore them.
It's not going away.
It gets worse. It gets worse. And especially if you're not that's like the role really of the broker is like, if you're not confrontational or you're like, I don't know what they're talking about, and I'm just super freaked out, and I just hope this goes away, chances are it's not going away.
But the one thing is definitely give people time to cool off. I've noticed like
24 hours.
yeah, people are pissed at the buyer, they're pissed at the seller, they're pissed at the lender. Just breathe, leave it alone, don't bring it up, let it go for 24 hours, and then people have a much cooler head.
Sleep on it.
Yep.
But just don't ignore it. Do not ignore it. Do not, if they're calling you, what's going on with this, what's going on with this, do not just ignore what they're saying. And you would be surprised how many people that's like kind of their strategy. If I like ignore it enough times, it will go away. That's not true. Okay. Now we're a little over, we're 20 minutes over. Do you guys have any questions or a situation that came up that you're like, hey, I don't know which avenue we should have gone? You guys know the avenues you guys should go. I just want you to be able to intelligently talk to your client about what their options are. Because like I said, I get calls sometimes, they're like, I want to like, you're person is unethical, or so-and-so was unethical. And okay, tell me about that.
What did Carolyn do now?
Oh, and so. Take my security deposit. I know I have 9 ferrets.
There is one right now where they're advertising that it can be financed as conventional and FHA. And it's clearly, if you go there, you know it's not, because there's so much damage to the property.
But they could do a new, whatever it is,
You could do a FHA, you could do a rehab
thank
FHA.
you, that's what I'm trying to say. So that's not necessarily true.
Well, FHA does have a rehab.
Yes,
Why
they
not?
do.
Because under the MLS.
I don't think that's an option.
It's not FHA.
But you're supposed to know that it
Well,
can go
it's
rehab.
But FHA, it's not FHA rehab,
Yeah,
so like, you would have to do FHA
And rehab.
Yeah.
The one thing I would caution people, I've had an issue before with writing loan programs, Alaska Housing.
I never marked Alaska Housing.
I'm super gun shy about marking Alaska Housing because it was one of those, I think I've told you guys this, those condos across from Wasilla Lake. Alaska Housing,
The PUD.
those are approved by Alaska Housing, all 48 units of them, except unit 12, and guess which one? I have?
12.
Why was number 12 not?
Because it didn't have an energy rating. I think
They
it was
didn't do
maybe
paperwork.
just completed right during the bankruptcy of that builder or something.
Yeah.
It just, for some reason, it's listed right on there, unit 12, not approved. So, yeah, so you just have to be very, very careful. You would really, I mean, I just don't mark Alaska Housing unless it's new construction, because I know all of those he'll meet all the requirements for that. But sometimes sometimes you'll get like a little one-man builder that builds one house a year, and he's like, I don't do the energy ratings. Okay, well then you probably should list it as the last house. Or if it's not having inspections or whatever, but that is one way. FHA is kind of tricky because it does have the rehab, the 203K. Yeah.
Thanks, now I was trying to think what's
I'm like 203B or
Yeah.
203B is the normal one, and the 203K is the, yeah, we see a lot of, that. I mean, you also see like one class we're gonna be having soon, it's a fair housing class. There's a lot of fair housing violations. And they're getting a little ridiculous, in my opinion. I'm not gonna get on a soapbox about that, but I mean, just.
33
most-
genders, really? Give me a break. Yeah.
I mean, that one's ridiculous to me, but
Yeah.
like his and hers closets,
Jack and Jill sink.
Alaska Man's Dream, great family home, walking distance from grocery store.
That's a violation?
Yeah, but it's making a
But you
wheelchair.
can't walk.
Oh, my God.
What about walking / what about boarding?
Rolling.
Rolling. I'm just gonna put rolling and cover it all. Rolling.
Stumbling distance to the bar.
Yeah, stumbling is all from the bar.
Well, because we have had issues before with, I mean, this is a total different issue, but we've had issues before with emotional support animals, because ADA says that there's a distinction between service animal and emotional support. Fair housing does not. So if I need a snake to feel calm, so whatever, I can, whatever. Well, I guess I don't know, snakes are, they follow me everywhere.
I don't like spiders.
Spider, I mean, I don't like spiders.
So is that still a thing you have to do with emotional support animals and friends?
I mean, it's kind of out there, like we just tread very lightly.
We can say, what's the question we could ask? What does your animal,
You can ask for,
what service does your animal provide? Yeah, we can ask that.
but it's tricky. I mean, I think it's honestly, this is not a time in the world where I want to take that
No.
one to court.
What answer are you looking
Right.
for when you say that?
Well, if you have a snake, I'm sorry, that's not emotional support. And thank God for Alaska Airlines, because they've started this,
Right.
and it's just gonna roll out, and we're gonna, yes, go Alaska Airlines.
It's all about the peacock, but.
The pony.
Oh, yeah.
Oh,
Was it funny?
Somebody brought a pony on?
The pony.
Yeah, that's
Is
what
there
they're
support
bringing
animal?
peacock.
Yeah, I read about the peacock and the pony.
I mean, if you ask them, what support does your animal provide? What
Can't make
answer
this
is?
What positive support could a peacock provide? That's medical.
Somebody else-
But a lot of times people say like, I have an anxiety disorder, this peacock is beautiful and calms me down.
No,
I don't know, we just tread very lightly, knowing that it could be an issue.
Why do you tread lightly? Just say no.
because they're taking South Pacific away because of something. You can't have Dr.
Come on.
Seuss.
Fill out that
And you want
paperwork
us to
for
take
information.
unfair
I get it.
housing? I don't think so.
Okay, was Hughes back too?
Yeah.
I didn't pay
Yeah.
attention enough.
I think he would be more so.
Why, because he's just like, he's
And
like,
what about City Sam?
He's a terrible woman.
Yeah, he was a.
he's a woman. Ah.
All right, our conversation's getting out of control, so we're ending this.
Oh my
Nothing
God.
is
That's not real.
Yeah.
Oh, thank goodness.
So who's in musicals and who loves the One South Pacific? They're after that now because the song, gonna wash that man right out of my hair. You can't say that.
But do you,